Ontario Superior Court of Justice between Suzanne Barlow as the plaintiff and the Citadel General Assurance Company as the defendant. Decisions on costs. The Longe. This matter arose out of a claim for long-term disability benefits. The defendant insurance company paid benefits from June 1st, 2004 to September 19, 2005, at which time the defendant ceased making payments. The defendant had decided that the plaintiff was no longer disabled. Following a 7-day jury trial, the jury found that the plaintiff was entitled to her disability payments of $4,000 per month from October 1st, 2005 to the date of the trial on November 2007. Together with the return of the premium she had paid during that period of time, the plaintiff's request to add a claim for aggravated and punitive damages was denied prior to the opening of the trial, as was a motion to strike out the defendant's jury notice. I was asked by both parties to fix costs in this matter. As I have received the written submissions, ruled on their pretrial motions, and directed the jury in this trial, I am in a position to assess costs in this matter. The plaintiff's position. Counsel for the plaintiff seeks a $50,000 premium on the basis that he took on the plaintiff's case on the basis that he would not recover any fees or disbursements unless the plaintiff was successful in a settlement or at trial. He says that the client had no financial ability to retain his services. The plaintiff also claims that the award made by the jury was as good or better than was made by the plaintiff offer to settle. The plaintiff made 2 offers to settle, and she claims costs on a substantial indemnity basis from the date of her first offer. Counsel for the plaintiff further claims that this matter was a complex matter vigorously defended by the insurance company and of great importance for this client. The defendant's position. The defendant points out that the plaintiff failed to mention her submission on costs, the offer it made to her close to trial to settle all matters, including further claims on her policy for $480,000. Premiums are no longer payable in cases where a lawyer takes on a claim for a plaintiff on a contingency fee basis, since Walker v. Ritchie was decided by the Supreme Court of Canada. Many offers were put forward by the plaintiff. The plaintiff cannot claim cost consequences on previous offers, as a subsequent offer implies the cancellation of a previous offer. Decision. It is not my role in fixing costs to engage in another piece of litigation. I find that the argumentative supplementary cost submissions of plaintiff counsel were not helpful. Counsel can find any number of cost decisions that, if improperly applied, can support outlandish positions. The plaintiff claimed a premium of $50,000 basically because she did not have the financial means to retain counsel. Paragraph 3 of the plaintiff's submissions on costs. The Supreme Court of Canada in Walker v. Ritchie Supra stated that the Rule 57.011 does not make the risk of non-payment a relevant factor for determining costs. That decision was followed by the Ontario Court of Appeal in Manufacturers Life Insurance Co. v. Ward. In that case, Manufacturers Life Insurance froze Mr. Ward's vested commission account. Ryler J.A., referring to the Supreme Court of Canada decision in Walker, found that recent amendments passed in 2005 did not change the Rule 57.01. She states in paragraph 69 to 71 that the concerns underlying the decision in Walker apply equally to the new language of Rule 57.01. First, the new factors, like the old ones, are neutral in character and can apply equally to plaintiffs or defendants. Second, the new factors do not specifically relate to the nature of the case or the conduct of the parties. They serve to uphold the principle of transparency and predictability that should govern cost awards. The 2 new factors merely make explicit the fact that, in the absence of a cost grid, there should be fairness and consistency in the amount that can be charged for a lawyer's time across similar pieces of litigation involving similar conduct in counsel. I would note that the phrase, quote, the principle of indemnity, end quote, in the new legislation is qualified. The listed considerations are the experience of the lawyer, the rates charged, and the hours spent. While the clause is phrased inclusively, a risk premium is not of like kind to these considerations. Clause 0b confirms this interpretation by insisting that costs be what the unsuccessful party could, quote, reasonably expect to pay, end quote. This engages the other concern about risk premiums explicit in Walker, that the defendant is not aware of his potential cost exposure because the premium is a private agreement between the plaintiff and his counsel. As noted in Walker, this is particularly important where, as here, a Rule 49 offer to settle has been made, and the defendant must be aware of the risk of refusing the plaintiff's offer. Wheeler J.A. canceled the $50,000 premium award with the same reasons I dismissed the plaintiff's claim for $50,000 cost premium in this case. With respect to motions or costs for steps in the proceedings prior to trial, the recent Court of Appeal decision in Islam v. Raham settled the issue, and I accept that while a trial judge has the right to order full recovery of costs for the entire case, there should be excluded from that award all costs related to steps in that case where the order was no costs or the order was silent as to costs. I will therefore only consider the motions brought before me at the commencement of trial before the jury was brought in to hear the case. I need not and will not consider any claim for costs that arose due to motions made during the months that preceded the trial. I reproduce the history of these motions taken from the defendant's submissions as I agree with them without reservation. In the bill of costs submitted by the plaintiff, there is an amount in excess of $30,000 claimed for motions. Motions were heard on September 29, 2006, December 21, 2006, May 10, 2007, August 27, 2007, and November 14, 2007. The motion of September 29, 2006 was to be heard in writing. The plaintiff was seeking to add a declaration to the statement of claim. This motion was withdrawn by the plaintiff on an agreement with the defendant on a without cost basis after the plaintiff received the defendant's motion materials. The motion of December 21, 2006 was for summary judgment. Again, the plaintiff withdrew the bulk of her motion prior to the hearing. Nevertheless, the plaintiff chose to proceed with a motion for partial summary judgment. The plaintiff was wholly unsuccessful in this motion, as it was dismissed by Justice Lally with no costs awarded. The motion of May 10, 2007 was by the defendant for a second defense, medical, and was opposed by the plaintiff. The defendant was successful in having the medical exam ordered, however the plaintiff was successful in having the examination videotaped. Given the split success on this motion, Justice Lally did not order costs. The motion of August 27, 2007 was for a leave appeal Justice Lally's order of May 10, 2007. The defendant was not successful in this motion, and costs of $2,000 were agreed to between the counsel. There was a day of motions argument at the commencement of trial in November 14, 2007. The plaintiff brought a motion to once again add a declaration to the statement of claim, despite the withdrawal of the motion in September 2007 seeking the same relief. The defendant brought a motion for partial summary judgment to strike portions of the statement of claim, seeking punitive, aggravated, and exemplary damages and damages for negligent adjusting. The defendant was entirely successful with respect to the motions of November 14, 2007. Therefore, the plaintiff was not successful in any of the motions for which she is seeking costs, with the exception of the motion of August 27, 2007, for which she already agreed to $2,000 in costs. Considering the fact that the plaintiff was generally unsuccessful in all the motions, and that costs have already been considered by judges who heard the motions, the plaintiff should not receive any costs for these motions. If the plaintiff wanted to receive costs for these motions, then she should have appealed the orders of the judges who heard the motion. In connection with the mediation on August 21, 2007, the plaintiff claims 3,350 hours spent by her counsel and 2.2 hours spent for a law clerk for a mediation that lasted 3 hours. I agree with the defendant's submission that this is an example of gross overbilling, and I will only compensate the plaintiff for 8 hours. The $58,000 claimed for trial by the plaintiff is excessive also. The plaintiff's counsel prepared a statement of law and a case brief that included more than 75 cases. I agree that the majority of the cases were with respect to the claim for aggravated, punitive, and exemplary damages that were struck by me. On November 14, 2007, following my decision on plaintiff's counsel's many motions, I admonished counsel in the absence of his client for citing no less than 8 cases to support a simple proposition. His factum was rife with such examples, yet 1 week later, counsel repeated the mistake again. On the matters of disbursements, the plaintiff had included expenses for a Dr. Cook in the amount of $2,142.14. Dr. Cook was never called as a witness at trial, and that expense is refused. The plaintiff included $635 for motion records. For the reasons mentioned earlier, the claim for such disbursements is rejected. The plaintiff also included a flat amount of $5,000 for a printing expense that is not supported by any documents, and $2,025.40 for photocopies that again is not supported by any documents. Those claims are also rejected as of the many cases cited were not useful to this particular case. As noted earlier, costs were awarded pursuant to Rule 5101(1) of the Rules of Civil Procedure. It reads as follows. 5701(1). In exercising its discretion under Section 131 of the Courts of Justice Act to award costs, the court may consider, in addition to the result of the proceeding and any offer to settle or to contribute made in writing, 0a, the principle of indemnity, including, where applicable, the experience of the lawyer for the party entitled to the costs, as well as the rates charged and the hours spent by that lawyer. 0b, the amount of costs that an unsuccessful party could reasonably expect to pay in relation to the step in the proceeding for which the costs are being fixed. A, the amount claimed and the amount recovered in the proceeding. B, the apportionment of liability. C, the complexity of the proceeding. D, the importance of the issues. E, the conduct of any party that tendered to shorten or lengthen unnecessarily the duration of the proceeding. F, whether any step in the proceeding was I, improper, vexatious, or unnecessary, or 2, taken through negligence, mistake, or excessive caution. G, a party's denial or refusal to admit anything that should have been admitted. H, whether it is appropriate to award any costs or more than one set of costs where a party 1, commenced separate proceedings for claims that should have been made in one proceeding, or 2, in defending a proceeding separated unnecessarily from another party in the same interest or defended by a different solicitor, and I, any matter relevant to the question of costs. I agree with counsel for the defendant as to how the above principle should be applied and reproduce his submissions. Rates charged. I take no issue with the rates charged by counsel for the plaintiff. However, as the defendant takes a position that there is no reason to award substantial indemnity costs, I'll review the scale of costs to be awarded. Amount claimed and the amount recovered in the proceeding. The plaintiff claimed for A, damages for breach of contract in the sum of $1 million, B, damages for negligent adjusting in the amount of $1 million, C, aggravated exemplary and punitive damages in the amount of $1 million plus interest and costs. The plaintiff received $100,000 for breach of contract. The claim for negligent adjusting was determined to have no basis in law and was struck prior to trial. The claims for aggravated exemplary and punitive damages were also struck prior to trial. The plaintiff was awarded nothing for mental distress. Therefore, the plaintiff recovered $100,000 out of a claim for $3 million. The defendant submits the cost should be proportional to the recovery. The modest recovery for damages should be coupled with a modest recovery for cost. In Boucher v. Public Accountants, Counsel for the Province of Ontario, the Ontario Court of Appeal states that an award for costs is not simply a mechanical exercise. Instead, the overall objective is to fix an amount that is fair and reasonable for the unsuccessful party to pay in the particular circumstance of the case, rather than an amount fixed by the actual costs incurred by the successful party. In Zesta Engineering Ltd. by Cloutier, another Court of Appeal decision, the court states that the cost award should reflect more what the court views as fair and reasonable amount that should be paid by the unsuccessful party rather than an exact measure of actual costs of the successful litigant. The principle of proportionality is essentially a principle of common sense and is fundamental to any decision on what constitutes a fair and just order of costs. This principle was considered in the case of Bouchinon v. Goetel Communications Corp., where Ferguson J. at paragraph 10 to 11 states, having said all that, the bottom line is that the proposed costs are excessive. They are excessive from two perspectives. Costs of this magnitude will make litigation inaccessible as a method of dispute resolution. Costs of this magnitude are also disproportionate to the value of the legal work reasonably necessary to represent a client in this dispute. If counsel do not use more restraint in deciding how much to invest in litigation, they will put both the bar and the courts out of business, which will profoundly harm the public whom we both serve. Further, with regard to escalating costs and proportionality, Mr. Justice Killeen in Pagnotta v. Brown at paragraphs 24 to 25 states, from my perspective, if lawyers wish to expend such grossly inordinate amounts of billable hours on relatively routine cases, they may feel free to do so, subject to their client's approval, but they cannot expect judges to encourage such inefficient expenditures of time when their costs are fixed following upon a trial. Judges and assessment officers have a duty to fix or assess costs at reasonable amounts, and in this process, they have a duty to make sure the hours spent can be reasonably justified. The losing party is not to be treated as a money tree, to be plucked willy-nilly by the winner of the contest. I agree that it would be extremely excessive to award approximately 2.5 times more in costs than the plaintiff recovered at trial. When I gave my directions to the jury, I told them to treat an insurance company as they would treat an individual. Obviously, counsel for the plaintiff was not listening, as he would not have made his outlandish claim for costs. Conduct of the plaintiff that unnecessarily lengthened the proceeding. This action was unnecessarily complicated by the plaintiff. This was a relatively straightforward action, a breach of contract. The plaintiff engaged in the following conduct that lengthened the proceedings: unnecessary motions with no basis in law, pursuing claims for negligent adjusting, exemplary, aggravated, and punitive damages that were not supported by any evidence. I agree with J. McDonald J's decision on limited success and small recovery in Stewart v. Canadian Broadcasting Corporation. She states the following: in fixing an award of costs that reflects the plaintiff's limited success and small recovery, the court holds that the plaintiff failed in numerous aspects of his claims against the defendant. Further, the legal requirement that determined costs on the merit of the lawsuit must take into account both the lack of merit in the plaintiff's failed allegations against the defendant and the low assessed value of the plaintiff's successful allegations. The plaintiff seems to rely on the fact that the defendant will continue to pay benefits on the policy in the future. This argument does not warrant granting additional costs. The fact that payments will continue flows directly from the jury's decision of reinstating the plaintiff's rate under the contract. In family law, increased costs are not granted because a wife obtains lifetime support from her husband that could amount to millions of dollars in the future. I agree with the defendant that the decision in Mills v. Raymond stands for the proposition that where a party makes a subsequent offer, it implies a cancellation or withdrawal of a previous offer. As a result, I ruled that only the plaintiff's October 12, 2007 offer and not her August 11, 2006 offer needs to be considered here. Further, I ruled that the defendant's November 12, 2007 offer can be considered and can attract Rule 49 consequences. Lindsay Paper Box Corporation v. Schubert International Manufacturing, Inc. was such a case where the court found an offer to settle does not have to be in the form prescribed by Rule 49. Rule 49.13 also states that a judge may take into account any offer to settle made in writing, the date of the offer was made, and the terms of the offer. I ruled the defendant's offer made on the eve of trial to settle for $480,000 plus costs to buy out the plaintiff's contract entitles the defendant to a 30% reduction on costs to be awarded to the plaintiff. I further ruled that if substantial indemnity costs are considered, it would be for services rendered under the plaintiff's October 12, 2007 offer. The plaintiff is asking for the following award: total fee $124,000, $830, total law clerk fee $6,000, $602, counsel fee $14,000, premium $50,000, disbursement $37,598, GST $13,975.98, the grand total of $246,908.96. I'm using my discretion to award costs and make the following reduction to the plaintiff's claim. I refuse the claim for premium at $50,000. I reduce the plaintiff's claim by 30% due to the defendant's offer. 30% is calculated on $145,432 after taking out the premium, disbursements, and GST from $246,908.96. Motions work $30,000. Disbursement, rejecting claim for Dr. Cook, claim for printing, and claim for photocopies. The plaintiff's bill of costs claims $58,000 more for trial. I rule that it is excessive and reduce it by $23,887.68. The total reduction is $166,909.46, and the total cost award, including disbursements, is $76,190. GST is added at 5%, and the grand total is $79,999.50.